Welcome to the session on day school applications. I'm really pleased that we have this session this year. We did have it last year, and people found it very useful, but they also asked for it again. This year, we've designed it so that it's as much detailed information about filling out the forms as possible. And I guess I'll just get the question thing out of the way. I think if you want to put questions in the chat, or if you find a moment when you want to ask a question, I think that's the purpose of this session. So please feel free to ask questions. I want to acknowledge before we start that I am living and working on the territories of the Coast Salish peoples, the Musqueam, Squamish, and Tsleil-Waututh peoples. It's always important, but today I'm thinking of that particularly because it's the anniversary of the missing and murdered Indigenous women and girls, and important to set aside as remember. Okay, I'm going to introduce our speakers. Gloria Cardinal works at the Indigenous Community Legal Clinic, which is part of the training at the Allard School of Law. She's worked there for several years, and then as part of that work has worked on a variety of issues. RTP hearings, the 60 scoop process, and more recently on the day school applications. She's thought a lot about the process and wants to pass on some of that information to you here so that you have the best application that you can. Especially keeping in mind that the limitation date is in July of 2022. Jayden Bourque also was an alumni of the Peter A. Allard School of Law at the Indigenous Legal Clinic. He's currently completing his PLTC, but also doing volunteer work like this to help share his knowledge of day school applications and other Indigenous legal issues. Welcome to you both. Thank you for taking the time to do this. And if I haven't forgotten anything, I'm going to hand it over to you.
Thank you. So we're going to bring up the first slide of the PowerPoint. I'll just say a couple of things about this presentation and working with Jayden, and then we're going to each introduce ourselves a little bit and just maybe tell you a bit about how we've worked with clients who have gone to Indian day schools, what that's looked like, and just how we're personally tied in with that. So the title is Indian Day Schools in Canada. The actual title of the class action is the Federal Indian Day School Class Action Settlement, and we refer to it as FIDSCAS. Jayden and I first developed this PowerPoint in July of 2020. And so that was 2 years out from when the actual limitation date is. And so since that time, we've closed probably 40 to 50 files. And so we've learned some things along the way. And what we're trying to do today is it's a little bit of a different presentation from our first one. And we're trying to include some really practical guides for you to help work through this process. Next slide. So Jayden, you could introduce yourself here.
All right. So anyway, thank you for having me back again this year. My name is Jayden Bourque, and as noted, I am an alumni from the Peter A. Allard School of Law, particularly the Indigenous Legal Studies program there. I had the good fortune of ending my law school journey with a semester at the ICLC, after which time I took on a small role as a legal advocate there, and then as an articling student after the fact. So I've been at the ICLC for quite a while now. I've been very heavily involved in that. I knew that I wanted to be involved with the clinic before I even went to law school. It was the primary reason I chose to go to the Allard School of Law was for the Indigenous Community Legal Clinic. And it exceeded my expectations the way I was really able to meaningfully give back to the Indigenous community right away in a very practical way. I can endlessly speak about the amazing experience I had there. I would, of course, have everyone get involved with the clinic in any capacity. I mean, it's very rewarding. Other than that, yeah, I'm just wrapping up PLTC. I've passed my bar exams, so I've just got a little bit of work to do, and I'm going to be setting up a practice with my sister, and the intention is to do full service Aboriginal. So that's a little bit about me. I'm excited for what's coming in the next year.
Thanks, Jaden. A little bit about my introduction to Indian Day School applications. 2 years ago, there was another class action, and it was a 60 scoop class action. And so me and my coworker at the time, we were walking people through that process. And when that was done, we had learned a great deal about interviewing clients and working with clients and working through the narrative. So when this class action came up, part of my job allows me to carry files. And so I choose to work with some Indian Day School clients as much as possible. And it's a very rewarding thing to be able to walk people through this process and to kind of hold their hand through the process, because a lot of people, when they look at the claim form and they pick it up, it's 15 pages of words, and people don't know how to just work through it page by page. And so what it allows us to do is just take a very a page by page approach and a client by client approach to this process, and to really help people get through something that to them would be very daunting. And even at level 1, some people really don't know what to do. And so we can give advice about the claims and where to go as you're walking through. Next slide. So I wanted to say something about this quote that I found. I was reading this book that I'm reading. It's called The Resilient Practitioner. I found through this process that I have really needed to teach myself more about working with people with trauma, and because when you have people walking through the door day after day and talking about these very extreme experiences that are very sad and very personal, it's good to arm yourself with information just about what kind of practitioner do I want to be. So when I'm working with clients and when I'm interviewing people and they're talking about things that are really personal and sometimes things that are really disturbing, as persons, we are each sacred. Each of us is a unique and amazing individual, gifted with intellect, character. No two persons are alike. And our clients, when they walk through the door, and you can even just see it in their demeanor sometimes, life has squashed them like a bug, you know what I mean? And the Indian Day School experience did that exact thing to our clients. What we're doing within this process is freeing them and allowing them to tell part of their story in order to, take off, some of the maybe baggage that they feel that has dragged them down for years and years and years. So we are able to help them come more alive, but also in that process of helping someone come alive, we come more alive because we're more connected to another person. So it's a very, I just find it's a very sacred experience to be able to help someone walk through this. You become close to clients because they're telling personal things, and they really trust the professional person to work with them, and keeping confidences and all that sort of thing. It's such an important thing to carry. So my connection to, Indian Day School is that I've always loved helping people. It's just, that is me. It's part of my character. I like helping people, and this brings a lot of meaningfulness to my life and my career. And I expect many of you feel the very same way. And that's just because this is why you entered this profession. And so we, by using resources like this, this book, it helps us to be a better caregiver to our clients who really need that help. Next slide. So I'm going to go through this introduction. This is basically the outline of what we're doing today. We did an introduction of Jaden and myself. We're going to go look at just a brief history of Indian day schools in Canada. Some of you may be unfamiliar with it. We have some documents that are important to read prior to getting into the claims process and helping your clients. We're going to look at who is eligible for Indian day school claims. And then we're going to spend quite some time talking about the client's narrative and what that looks like, the definitions of harm, and what the different levels of a narrative might look like. We're going to briefly mention the ATIP request, although we're going to mostly leave that up to one of the handouts that we've given you. And then there's additional information at the end. Next slide. So I want to talk about this painting a little bit. 2 years ago, when we were first, or 1 year ago, when we were first doing the research to present on the Indian Day School, I found this painting online and I posted it on Facebook because this artist, Lawrence Paul Yaxwalabtam, he's one of my favorite artists, just in the way that he depicts the modernity. He mixes modern and traditional in all of his styles. And so I thought that this one was really fitting, because what I was looking for is a picture of a child who'd had their hair cut, because that was one of the first traumatic events that happened to some of these children as they went into the Indian Day School system, is getting their hair cut. And so I posted it on my Facebook and mentioned that I was just, I thought it was a really significant painting. And he responded to me on Facebook and he said, he told me the story of this person. He said, my little schoolmate friend, we were in the same class. We were walking together and she had a big smile on her face. And she asked me how I was doing. She liked to skip a little when she walked and talked as we went to class that day. Later that night, she died at the Kamloops Catholic Indian Residential School from a tick. Some days later, our class was marched down to the graveyard and we all had to stand there until she was buried. Then we were marched back to the classroom. In the classroom, many classmates were crying. It was a very, very sad day, and other children died at that school. So this story that he told me, is a very powerful story. And even though this happened at an Indian residential school, it's not unlike some of the stories that happen to people that we know within the Indian Day School. So it just was meant to bring, sometimes art intersects with life. And this is just a very good example of an Indigenous artist putting that kind of thing out there. And it was a very personal story for him. And he thanked me for posting it on my Facebook page. Next slide. So just a couple things about the history of Indian Day Schools. Indian Day Schools and residential schools were originally created in Canada in the late 1800s and modeled after the British boarding school, which had been a method of schooling in Europe for centuries. So Indian Day Schools were not new by any means. For centuries, children have been sent to boarding schools in every country. There were 4 main denominations that opened schools across Canada: Catholic, Anglican, Methodist, and the United Church. And this was in the 1880s. A typical day at Indian Day School would be education with different subjects in the morning, then in the afternoon, chores or cleaning in the school, as well as some sort of catechism related to the church that oversaw that school. It could be Catholic, Anglican, Methodist, or United Church. In 1920, the Canadian government stepped in, taking responsibility for these schools, both residential and Indian Day Schools. There was a movement to have more students be able to go home at night. And in 1920, there was 247 Indian Day Schools, with that number increasing to 699 up into like the 1970s and 80s. Indigenous children from kindergarten to grade 12 attended Indian Day Schools. These were usually located on native land, either next to residential school, part of a residential school, or close to the church parish that was on the nation's land. Indian Day Schools were only different from residential schools because at the day schools, the children went home at night. In every other way, curriculum, church catechism, untrained school teachers, afternoon chores, the Indian Day School students had the same experiences as those at residential school. The predominant memory for these students is the punishment received for speaking their own language. The most common punishments that are spoken about in the narrative are verbal abuse and name calling, hands being strapped, other body parts being strapped, ears pulled, hitting or being hit with objects, whipped, standing in the corner, being made to kneel in the corner. For the students who were pulled by the ears or smacked on the head, long-term physical repercussions such as hearing loss and headaches became lifelong health issues. Those are just some of the things that we've heard from many of our clients. Next slide. So Jaden, if you could talk about this one a little bit.
Yeah, of course. Well, you guys, I won't read the slide for you, but the gist of it, we do get down to a lot of the abuse, and this was generally one of the first questions we'd be asking when the survivors, the language issue, the culture issues, were they allowed to live their life and their truth? And the answer was overwhelmingly no, not ever. So with respect to a lot of the abuses Gloria mentioned, there was a lot of the hitting with the rulers or the yardsticks. Sometimes it was go back out to the schoolyard and get me a switch or a branch from a tree and we bring it back in. And sometimes they'd say, yep, good enough. Sometimes they'd send them back out. They say, you need to go get a bigger one, right? We've had more than one survivor tell us that story. And then they were dragged in front of the rest of the class and flogged in front of the rest of the class, right? And it could be something as simple as they just wanted to speak their language. They just wanted to maybe eat some of their cultural food, right? We definitely had clients that I've worked with that had their food thrown into the garbage and they didn't understand that, why it was thrown into the garbage. And I said, well, what is it that you brought in? And she said, well, I brought in some bannock from home. I was always allowed to eat food, so I was really surprised by that. And I said, well, it's because it was Indian food. It was bannock. And, that caught her off guard. She hadn't considered that. It's one of those things to think about, is that not every survivor is even familiar with colonization, even though they've been under the assault of that their entire lives. And this is some of the important work that we get to do when working with the survivors, that we can kind of fill in some of these blanks for them as we go along and through this healing process, hopefully. Yeah, next slide. And so I guess you guys are well familiar with how this class action has been started by now. One thing to keep in mind is that approaching limitation date, there's still no word or update that this is going to be extended in light of COVID and the ongoing pandemic. I would expect to see something about that soon. I've certainly seen petitions going around asking that be extended for at least the length of the pandemic, which makes complete sense to us. One thing that you guys will see in that FIDSCAS how-to that we've provided with you, which is a very thorough document about this whole process, is that it is actually built into the process that there is the potential for a 6-month extension. You just have to have some extenuating circumstances or something worthy of them granting that extension. So at this time, we're thinking that we might have to just for every client say we're going to request a 6-month extension in light of the pandemic. Hopefully they'll do something about that. It won't come to that for us, and they'll maybe give us another few years, which I think is sorely needed. Next slide. Okay. So this is a breakdown of the final agreement, and you guys can actually go to the Indian Day School website, and all these court documents are actually posted up there. So you can actually go read through the final agreement and see how everything's broken down. As you can see on this slide, it's telling you exactly what that breakdown is. Some of the particular points worth noting is the Schedule C, where we're really going to get further into a discussion of that section of the entire agreement, because this is where the harm levels really come into play and all the nuances. And, it's really, that's the stuff that's going to drive the narrative when you guys are working with clients. Of course, Schedule K is the list of approved Indian day schools. They do firmly say that if day school is not listed on there, that they are not eligible for the claim. We're in the process of actually fighting them on a couple of those right now. That's a work in progress. I don't have much I can report on that as of yet. It's a work in progress. If you read through the final settlement carefully, and I've detailed this in that FIDSCAS how-to that you guys will have access to, you can see some of the language that contemplates a scenario where a school might not be recognized, but they might actually refer it out to consideration from the exceptions committee. So yeah, some interesting little things there. If we could move on to the next slide. All right, yeah. And well, this is just a breakdown of Schedule K. And it'll be one of the first things that you will do when you have a client walk through the door is you'll ask them if they recall which day school they went to. They might not recall the name. They might, of course, only recall whether it was on res at this area or in roughly this geographic area, and you'll have to peruse this to see if this lines up. You'll also have to take note of the dates because they do specify the time at which it was actually under federal control. Of course, only things that were under federal control are eligible for this class action. I would say that there's going to be more class actions in the future for anything that falls outside of that. Of course, you guys, I did see there was a question down below about the Justice for Day Scholars class action. I'll just speak to that really quickly right now. So that has been approved. This is for the scenario in which someone was a day scholar at a residential school. So that's still a federally controlled entity. And that will be their recourse to get some compensation. For the federal day school settlement that is the subject of this is they were not a day scholar, which means they were at a day school as opposed to a residential school. And as you guys begin to work with some of the survivors, you can see how murky that can be. Of course, there's many instances where a survivor would have been at the residential school for 1 year. However, the day school was in the same building and they were considered a day school student for the next year, and so on and so on. I've seen a lot of that in the time that I've been working with survivors. It becomes very difficult when you're trying to write that narrative. And, it's honestly quite stressful because you're going to see generally horrific abuse that could have been on either or year. And you're going, well, is the administrator going to recognize this abuse generally? Is it only going to be for that year that they were absolutely a day scholar or a day school attendee, right? It's very nerve-wracking. Either way, you'll have to pay close attention to Schedule K, see what those federally controlled dates are, take note of any time where there was a transfer to another entity. So you will see that clearly denoted in that Schedule K. Oftentimes, it can be federally controlled for maybe 10 years, go to another entity, and it's back under federal control again. So do take careful note of those dates. If we could go to the next slide. Again, and this is what I've kind of spoken to already. So this will be any person who attended a federally controlled Indian day school on that Schedule K list. They are very particular about it. Again, I've noted we've taken exception to a couple files that we're working on where we have actually written to the administrator, submitted a full narrative, and said we're going to contest these recognized federally recognized dates because they don't actually align with what the survivor and their families are saying. And in many cases, there might be a compelling reason why we believe that. For instance, I'm working with one client that her entire family attended a day school in the Port Edward Cannery, and the recognized date starts 2 years after she was in attendance there, but there was no changeover of the staff, no changeover of curriculum. It was all Indigenous students. However, she said after 2 years of her attending that school, they then moved into a new building in a different part of the town where there was now some Japanese students and some other settler students. However, we're told by the administrator at this point that they're only recognizing the dates that they have in their Schedule K. And when we're telling them like this, it really does not add up, because we can see a very clear transfer of power or control at 1.2 years after the student was there. In this instance, where you guys will see this in that how-to guide that we provided you, where there might be a contest between what the claimant says versus what the administrator says. If there's no clear proof, they are supposed to side with the claimant. So that's why we're actually trying to pursue this kind of file. We know that it's an uphill battle. I've already seen that. They clearly did not know how to respond to this narrative and this claim package that I submitted to them. I very clearly said, could you please flag this for the exceptions committee, because this is something that is contemplated in that final agreement, and, they sent me back the dates don't recognize. They just sent me back the standard claim form. I was like, you've chosen not to engage with what we're doing here at all. So like I said, that's a work in progress. So yeah, eligibility, find that out right away. See if it is recognized as a Schedule K, aligns with the federally controlled dates. If that all works out, you're golden. It's easy to move on from there. However, sometimes you'll have to keep in mind that a survivor might have attended multiple schools, some of which were maybe as a day scholar, maybe it was just a residential school, and so on and so on. And you'll just have to work through an entire narrative, get that person's life history so you kind of know whether they're going to be able to be eligible for this class action. It's a long process. Next slide. And I think you were going to say this, Gloria?
Yeah, I'm going to jump in here and start going through the claim form overview. So we're not going to walk you through the entire claim form in this presentation. There is excellent videos out there that really do a page-by-page, step-by-step guide on how to walk through the claim form. But we're going to give you an overview in general terms of kind of how we approach this. So we're going to start by doing the first part 1, part 2, and part 3. And then we're going to look a little bit then we're going to start getting into a little bit more talking about narratives and just the importance of that, because as you get into part 4 and 5, that is where the client needs to decide, where does my story fit? Or we help the client decide, where does my story fit? So the first part of the claim form is, one thing about these claim forms too, I really recommend everyone to take the claim form, read it out loud from beginning to end. Even just doing that one thing at the very beginning will give you a really good general overview of what they're asking for. Because what we're doing is we're answering the questions that are laid out in this paper. So let's go into the next slide. So let's start at the beginning. We've got a cover page. It includes a caution. It basically lets you know that you're going to be working with people who have experienced trauma and that you need to kind of prepare yourself for that. And then there is some numbers that are available for legal assistance. The claim form also includes, on the next page, it includes the limitation date, which we always keep forefront in mind. And in fact, that's why I asked Lois if she could schedule this workshop at the beginning of the Legal Advocates Conference, just so that it gives extra time for people who are working with clients, because at this point, it's coming down to the last, 10 months. And as long as, like Jaden was saying, there is a potential for the 6-month extension, but the claim has to be in by that date. So the claim has to be submitted, and then we can ask for possibly an extension. So we've got less than a year to get the claim forms in. There's a general statement about Indian Day Schools, where to find Schedule K, which we sort of already talked a bit about, and available legal advice. Next slide. So these 2 pages are very important because for level 1, well, for every level, but these have to be filled in, which is the contact information of our clients, their status number, their social insurance number, their date of birth, their name, if they have any aliases, and then their contact information. And then in part 2, it goes into the Indian Day School that they did attend. And so sometimes we have people who tell a story of going to 3 different schools. And it could be that just one of them is in that list, federally listed guide. I include all of the schools, but we know that when they look at this application at the end, they're only going to probably take into account what happened at the school that is listed in Schedule K. So this is kind of the information that we're working with. But as long as one of the schools is on Schedule K, we're all good to go. So we look at the school attended, where this could be more than one school, and when. Sometimes students, they don't know when they went to school. I always begin with their birth date and count forward 5 or 6 years. That's the first year that they attended school, because I just go with the pattern of children go to school when they're 5 or 6 years old. And so we just go with that. If someone doesn't have they can't remember the exact time, which is understandable because they were very young. Next slide. The claimant and witness statement. Now, this is very important. The claims administrator, this is the person who gets the claim forms. They review the claim forms and they make sure the level of harm selected goes with the information you have provided. There's one piece on here, just in the middle. It says, have you already received a settlement from the Government of Canada? And there's yes or no. We always put in no, because as far as our clients know, they have not received another settlement. And then this witness and the signature that happens is, so the claimant signs and the witness signs, you sign at the same date. The witness must witness the claimant signing the document. So it happens, usually in your office or in your presence. And then if you happen to be applying for level 1, this would be kind of the end of the process, is these first 5 pages where there's the contact information. So it's really important to just carefully read through with your client that you've gotten everything correct, dates as correct as possible. Sometimes we've had clients who really didn't want to go into doing the narrative. They just want to do this first part of the form. And if they're adamant about it, then we say, yes, we will do level 1 for you. And that's all that we do. So, but just make sure that you really look through everything that you've got, their ID, copied on both sides. It's all readable. And, just sometimes little things can delay an application. So we're very careful to make sure the contact information is correct. And we always say to our clients, if you move or if anything changes, as far as contact information, you must let us know, because that is how the Indian Day School adjudicators, they don't contact us, they contact the claimant. And so we have to have current contact information. Next slide. Okay, so I put this slide in. This is a new one because congratulations, if your clients are only going for level 1, and this is everything that they want to do, Deloitte will be sending out a check for $10,000. Now, I have a little story here about one of our clients that came in actually in November of 2020 originally, and only wanted to go for level 1. And so I thought, just think on it. Let's decide if you want to do a narrative, because I always want to give the clients a chance to do narrative. I just think, you might want to tell your story. So we didn't send it in, but basically the application came in complete. I had done the witness signing and everything like that was done. So he went away. Well, then 6 months later, the client had not come back. And so we started to try and contact the client to say, could you please, we want to finish your application. Do you want to do the narrative? And so we ended up sending out a couple of closing letters because we couldn't get a hold of this client. And the letters came back from the place he had been living in, the downtown east side, in one of the hotels. And 2 letters came back that he had deceased. And so I had pulled his file. I looked at the file, and everything was complete for level 1. It was signed, sealed, everything was ready to go. What I ended up doing is mailing it out. As I thought this client might have family, so I just mailed it in. Well, anyways, then about 2 months later, we received this check in the mail for our client, and I ended up going into his file. I pulled the original intake form, and I started phoning the numbers of the people that he, his contact numbers. And the first number I contacted was his sister. And I said to her, I have something for Mr. So-and-so, but I heard that he is deceased. Is that correct? And she's like, no, I talked to him 2 days ago. No. And I'm like, no, I said I was informed by mail where he lived that he was deceased. She said, no, that's not true. So we had this kind of crazy conversation, and it turns out he was not deceased. And I said, you know what, it's really imperative that you contact your brother. Could you give him a message that the ICLC has mail for him? And as soon, this is important. So I waited a couple of weeks, and there was no response, and the person didn't call in. And then and then I called again the numbers, and it was his sister, and she says, you know what, I did call him, but I'll tell him again, there's this mail. And he came in the next day, and this was a real surprise for him. He's like, he was really overjoyed, that he got this money, because probably slipped his mind, but he said, you made my day, and how can I thank you? And I said, you know what, bring me a cup of coffee, I like lattes, I think that would be nice. But sometimes we, in our client work, just even having a level 1 being, is something that can change their life, and this turned out being, at first, I didn't even know if our client was still alive. Turns out, yes, he was alive, which is very good. So he was a recipient of the level 1 claim. Next slide.
All right, I think I'm up. Okay, so again, we're going to get into the significance of the narrative, and this is definitely where the heavy lifting is involved in federal Indian Day School class action settlement claim. This can take months. Honestly, it can take several months depending on your client, whether they feel comfortable being able to talk frequently for long periods of time. That's not always the case. Every client's different. But why the narrative is significant, and why we at the clinic always will try to push even those who think they are just a level 1 claimant to really delve into the narrative component with us, is that oftentimes they don't realize the harm that they've sustained in the time that they were at day school. And what they think was just very normal, we have seen can probably rise to perhaps a level 4 claim. Just think about that. Sit with that for a moment and think about each person who just assumes that level 1, that's probably going to cover me, right? What could be involved with that? Well, level 1 is very easy to fill out this claim form. As Gloria noted, it's those first 5 pages. You don't have to delve into anything. There's nothing complicated necessarily about that. We can see by the nature of the settlement and colonization, which this is a very colonial process that can't be denied, that there is definitely steering people towards taking that level 1 settlement. We can't in good conscience at the clinic sit with that. So we're always trying to get clients to be receptive to the idea that maybe we could discuss this and do a narrative and really see if it's going to be level 1. I think so far I've only had about 1 client who said he could not bear to speak about his experience there. So we respect his wishes at that point and did put in a level 1 claim. However, I also worked with his brother, and you guys heard the news, of course, at the Cowessess Day School. These were students from there. I come to learn that my client, who I did actually get to go through the whole narrative with, witnessed his younger brother get murdered by one of the staff at the school. There was copious sexual abuse at that school. I wasn't surprised to see the body count in the hundreds at that school. So this, just for some perspective there, we had someone take a level 1 who had pretty much the same experience as his brother, who I put in for a level 5 by the time we were done. So this is where that speaking truth to power and truth is justice really comes into play. When we set out to work with a survivor, our goal is, how can we help you heal? We know that even for a level 5, which is the maximum of $200,000, that's really quite meager for the abuse that they've sustained. So we choose not to approach the day school settlement in that manner. It's really, let's engage with this as a truth gathering or truth sharing exercise. We try to make it decolonial. We try to indigenize the process. There's greater things that can be gleaned when we approach this work that way. For instance, I've had several of my clients say, even if they weren't awarded anything, it was going through that whole process, and really that helped them to understand themselves better and why things were the way they were, why they make some of the choices that they've made. Is that I can't thank you enough for that. That in itself is worth it. I know myself, right? So if we can approach it that way, that's what we choose to do. Let's go to the next slide. Okay. Again, and you can see this is just why we never settle for a level 1. I do like the depiction on this image. So we see that scarring carried with each of our survivors. So it's very seldom that we have a day school survivor come through that maybe wasn't also part of the 60 scoop, for instance, right? Oftentimes there were also residential school survivors. And that's just something to keep in mind. There is a perception that day school could somehow be not as severe as residential school. I can see very clearly that there's no difference whatsoever between the length and how harmful it was. The abuse is the same. It's as bad as you could possibly fathom. I've seen that from multiple clients. It wouldn't matter if it was at residential school or day school. The abuse is the same. Let's go to the next slide.
Jayden, we have a couple of questions in the chat that maybe are relevant here. Someone's asking if you can do a level 1 application without a statement.
Yeah, you absolutely can. For a level 1, no narrative component is required, right? It's our policy to try to engage with the narrative with our clients just to ensure that they don't, in fact, exceed that level 1. Right. But otherwise, if they're pretty sure that, there was no abuse whatsoever, this process is quick and easy. I've done a level 1 file for a client in about 15 minutes. It can be done that quickly. Again, it's designed this way. They want you to take that level 1, right? So, yeah, it's
and
very...
then, sorry, another related question is, if someone accepts a settlement, then do they waive the right to apply for a higher level?
Absolutely. And, this is orchestrated this way. It's not only that scenario where they've accepted it, but even if when they submit their claim, select a level, they will try to lock you in there, it seems. Now, even though in the settlement, it is contemplated that if the assessor determines that the level you've selected doesn't really accord with the level of abuse, they are supposed to make that adjustment, right? But we have seen some files where whoever the assessor was didn't actually make that decision, even though there was very clear proof that it was a level 4 as opposed to, say, a level 2, right? So don't count on it. Don't count on the assessor to do the right thing. That's what I'll say. And that's why we always tell our clients, we don't want to rush this process. We want to do a deep dive. We want to unturned every stone possible. We want to get witness narratives. We want doctor's notes, everything we possibly can get. For this reason, you have no real reason why you should trust the assessor when you understand this process and what it is. This is a perpetuation of colonization, period. So you have to arm yourself with that going forth. Were there any other questions about that?
No.
Sorry, it's Jen. These are my questions. So do you find that sometimes you're submitting a fair bit of evidence alongside the claim?
Yeah, absolutely. You know, if we have the time, we will get everything we possibly can. Therapy records, medical records. We'll chase down the attendance records. We'll do everything we possibly can. That being said, I mean, there is this sworn declaration as part of the claim form. And what that does is it stands in place of any of those things that you're not able to track down. What it is, you're swearing that this is true. And I've been assured that that is given heavy weight by the assessor. I have seen that by some assessors, that certainly is true. For instance, I worked with someone on a reconsideration. They were denied their claim. We had a very quick turnaround on that. It wasn't to the point where I'd be able to track down all those other records necessarily to get that, because the clock's ticking once someone gets reassessed. So that's fine. We just did a really thorough narrative and submitted that. And actually they were successful on that claim and were awarded a level 4. Now, that being said, when we have the ability to start from scratch on a claim, get everything you possibly can, always expect them to push back, right? And you never know. Like, this is the thing. I've tried to seek the guidelines from the assessor through like an ATIP request. And I was told that, you know, you can't see any guidelines. They won't speak to whether there actually are even any guidelines. They just say, look to the harm level chart. That's how you'll know. And we're like, well, how can we be sure that there's any consistency from the assessor when they're looking at these claims? Because so far I've already seen that they're not actually that consistent. I've seen very clear level 4s not get assessed to maybe a level 4. And that's one that we're actually contesting right now. Now, that being said, on that particular claim, the person did try to do it on their own and selected for level 2 without really understanding the settlement and, you know, what the harm levels really were. And it's a situation where they kind of locked him in. And even though when they do see very clear level 4 in that narrative, in this case, the assessor didn't make that adjustment for them. So that's one that we're going to continue to contest. Yeah, it's tricky. Just, I can only say, do everything you possibly can in the time that you have, right? You're not always going to have enough time to do everything, particularly in a reassessment. When the clock's ticking, you've got to get it in, and that means you're going to be relying on the sworn declaration. But that being said, you will rely on the sworn declaration for every claim regardless, because it doesn't hurt you to. It just gives a little more heft to that narrative. You're saying, we're swearing that it's true. Here's the sworn declaration. It's great if we have all those other corroborative aspects in the way of therapy records and such. We have a question from Arnold, I believe.
Yes. First off, I didn't hear you mention it, but a lot of First Nations don't have status cards that are treaty. So in that place there where they ask for the status card, you put, like the Nisga'a, for example, you would put the Nisga'a citizenship card number?
Yeah, you can do that. Yeah. Now, also something to be aware of, even if your client didn't have a status number, or maybe they didn't even have ID, you can actually use the sworn declaration to submit that level 1. You're just swearing to their identity. So if you, some reason, didn't have those things, there's still a way to do it.
Yeah, I'm just saying that for that part of the information that you're gathering, that's what we've been doing. We've done about 525 out of my office so far this year.
Yeah.
But I think one important question that should be asked when people come into the office, because I basically fill out their application forms for them, and that's how they want it, so that we make sure everything's covered. Now, when I know that there is a claim that should be higher than level 1 and that, but they want to go to level 1, I ask the question, has somebody asked you or told you to just go for level 1? Because I found out when I was in one of the reserves for a week doing the day school claims, I think we did 10 or 12 level 4 or 5s. They were being told only to apply for level 1 by people in the band office, because their family that is working in the band office also looked after the day schools.
Oh, wow.
So they did not want their names on there. And I said, well, that's BS. I says, this is what you're entitled to. Many of them were uncomfortable to do it on the reserve. So when they came to Rupert, we did them out of our office. But you've got to think that you got to ask that question. You're not interrogating them, but you want to make sure that they get the best compensation package that they can get based on the abuse that they happened, and are not being coerced into accepting less to save somebody in the band office or administration or what have you family name for what was happening back then.
Yeah, that's an excellent point. And actually, we'll get into a little bit of really emphasizing the confidential nature of this with your client. Sometimes you'll have to reiterate that several times before someone even wants to speak about it. So that's an excellent point. Next slide. Okay, yeah, this is the prescribed process that we use in approaching an entire federal Indian Day School class action claim, particularly with the narrative at the clinic. And this will be in that FIDSCAS how-to. When you guys have a moment to actually look through that document, where you're actually going to see examples of narratives and witness narratives, everything, we're going to expound upon each of those points within that document as well, so you can really understand our thinking about it. So yes, first thing is to, when your client walks through the door, take the time to establish a rapport with your client. I know for me, and first thing I generally do is I tell them about myself. I'll mention to my client that I'm Slavey Dene Cree Métis. I have grandparents that were in residential school and day school. It's a great way for me to start to establish a rapport with them. We're not even going to look towards what's within that claim form at that point in our interactions. It's get to know a little bit about me. I want you to know why I do this kind of work, why I feel this kind of work is important. Of course, when you have that shared family history with one of these survivors, I mean, that's an excellent way to get to that trust. So I would say do that absolutely. Of course, there's the discussion of the availability of therapeutic resources. So what might be nice, you can point to the resource that's on the claim form itself. However, you can also search and see what other local resources might be available to your client, which is actually an excellent thing to do. Not that they'll take you up on that. I've had very few survivors who actually did want to engage with any kind of counseling in addition to working with me on this narrative. In fact, most of them found that to be very healing in itself, but each client is different. Number 3, advise your client that they will have significant control over the process and can take breaks as needed. And this is why I mentioned that sometimes a claim might be taking several months. Sometimes you might get that person who's really only capable of speaking about this right here, right now. They've sat with it their whole lives, probably haven't shared it with anyone else. They're being incredibly courageous at that moment, and you've got to get it down right then and there. I've certainly dealt with a few of those clients. So yes, next thing would be to send drafts of your narrative to your clients so you can clarify and make revisions throughout the process. So when I'm dealing with the clients, we're usually telling them, that it is going to be a long process. Ideally, we'd like to meet multiple times because we want to continue to refine that narrative. There's going to be things when you're taking notes from someone and they're just telling you everything, there's no chronology generally when someone's sharing their story with you. So it's going to have to be revisited. Now, bearing that in mind, you also know that you are no doubt going to re-victimize your client. Don't even think for a second that you won't be re-victimizing the client when you're speaking about this. There's no way to do this kind of work without re-victimizing. In fact, it's offensive to me that this settlement has been sold to everyone as though this will really downplay or, get rid of any kind of re-victimization. That's simply not possible. So yeah, you will be revisiting this as you go along and you're drafting and you're editing. It's going to take some work. Also, generally, when you go and speak with a witness, you might be revisiting your client's narrative as well. It's a long process. Sometimes you're not able to speak with one of the witnesses for maybe a few months. So we generally have a file open for a while if it's one that we're starting from scratch. Next thing, advise your client to keep a pen and pad with them to write down their memories, as this will bring up suppressed memories, and that has proven to be the case for every single client I've worked with. I'd say that the vast majority of them did have nightmares from the time that we started to revisit that. And, the things that they just would remember, days after speaking, weeks after speaking. Sometimes they get enough courage after they've opened up to you to maybe speak with one of their family members who attended the school. And, then they go, wait a second, you said that name, or you said this teacher, and that made me think of this. This is why I say, keep that pen and paper with you. We're going to keep revisiting it. It's our goal to get 100% of your life story in there if possible. It's not just about what happened at day school. Really, it's about what happened at day school, but more importantly, what happened after, because so much of this process is going to rely upon demonstrating long-term mental impairments. This is how we climb that level of harm up. So it's going to be very important. Number 6, although the focus of the assessor is on harms incurred at day school, expand your narrative to include a greater history, just as I've spoken to. So important. It really is what makes the difference between a level 2 claim and, say, a level 4. Next thing is to humanize the survivor in your narrative. Now, we've actually provided you with some narratives for you guys to look at. We really discuss that narrative process and the whole reasoning behind it in that FIDSCAS how-to that we provided you with. I personally like to put in every possible idiosyncrasy of my client. I want to refer to them by the name they prefer. If it's a nickname, I'm going to refer to them by that nickname. If they have grandchildren, I'm going to put their grandchildren's names, and, anything we possibly can do to humanize this person in the eyes of the assessor. It's really important that we do it. They have to know that this is a human who's endured this. And, obviously the more of that survivor's personality you can put into their narrative, it's only going to be beneficial. Next thing is to end your meetings on a light note. Again, you're going to have hopefully a lot of meetings. The vast majority of our survivors that we work with are actually grandparents. So it's one of those little tricks that I've learned is you can always put a smile on the survivor's face when you ask them to speak about their grandchildren to you. So that's just something that I like to do. Next slide. Okay, so you guys have probably all had a look at the claim form and you've seen that harm level chart and you went, what? How do I make this distinction? It's very unclear. And, I've sat and looked at this thing many times. So I think I do understand it now, but on initial glances, it's very tricky to know wherein your client is going to fall on the harm levels, right? So just because that can be tricky, one thing that we'll advise people to do is if you're in doubt between a level of harm, select the higher level of harm. There's really no downside to doing so. The worst case scenario is that they'll be reassessed to the lower level. That's it. right? At which time you'll then have time to address that by seeking a reassessment. But yeah, no real downside because they might be awarded that higher level to begin with, right? So when we get to defining harms, because we don't find that harm level chart too useful, if you look into the final agreement, you'll come into Schedule C, Section 44, where they're going to give you a list of many different harms that they recognize. Now, these aren't things that are going to be described on that harm level chart. So it's very easy for people to overlook thinking about these kinds of things. Some of the things that you might see is suicidal ideation, things of that nature. It could be familial breakdown. It could be, anxiety associated with learning. And bear in mind that even the things that you see on Section 44, we can go beyond that. It can be any harm that you have discovered or you've described. If you think something was harmful, if you can tie it to something psychological or a long-term impairment, put it in the narrative. It could be, yeah, go ahead.
I just want to jump in here a bit about the Schedule C. So the Schedule C, it actually lists probably 25 to 26 different outcomes of what the harm may have, what the harm had caused in a person's life. And so it could be, emotional issues, PTSD, having trouble sleeping, not being able to connect to a career, losing your ties to your community, losing your language. There's so many of these things that every one of our clients walking through the door has experienced those things. So when we're talking about defining the harms and creating the narrative, that's why we stress so much the importance of the narrative, because it's within that story that we can even try to determine a level of harm, because most of our clients, they have some symptoms in their life of, that have plagued them their entire lives. So we're trying to catch everything, within, it's basically a lifetime that they've had from Indian Day School, where it might have been 2, 3, 4, 5 years, but they're still experiencing some symptoms of things that have been caused from so many years ago.
Jaden and Gloria, there's a question in the chat too about whether you find it helpful to have a support person if a client wants that.
I always keep a list of local resources for clients, because I'm connected to different organizations in the downtown east side, and most of our clients are people who are living within 4 or 5 blocks of the ICLC, and so I try to connect them locally with someone who can give them counseling. There's counselors at the Vancouver Native Health that are drop-in, and you don't have to make appointments, and so I tell people about that. And I mean, like Jaden was saying, not a lot of people take us up on going for counseling, but we always have something ready for somebody, because there are resources within the local community that are available if people want to take advantage of that.
Yeah. What about having someone at the interview with the client? I think that was part of the question too.
Yeah, there's certainly been a few of our survivors that we work with who have had someone sit in on their sessions. If that actually makes them more comfortable and they feel that they can speak freely in front of that person, that's fine. I would still like to have the ability to speak with them alone, just to make sure that I'm getting the full story and they're not holding back any details. But certainly to get the ball rolling, if they feel more comfortable having someone there, absolutely. Whatever gets them speaking, it's not a hindrance.
Yeah, and I just recently was doing an interview with someone who brought in his support worker, someone who's his counselor, and yeah, we're totally open to having that happen.
And what was on the next slide, Gloria? Does it actually show us Section 44?
No, we didn't include that this time, just because it's something that people could really look up, and I think I might include it as one of the handouts.
Sure.
But we just basically did a kind of an overview of what what the survivor class is and who the survivor class is.
And I believe it's in that FIDSCAS how-to document as well. Okay, so we can see that slide.
Yeah.
Okay, and yes, this is getting back to determining harm. We've spoken about how challenging it can be to determine or fall on a level of harm. Some things to be aware of is, if you're reading the slide there, perpetrators of harm, sometimes people aren't aware of the fact that they could have been harmed by anyone. It's just, did it happen on the school grounds? That's what's important. It doesn't matter if it was just a teacher. It could have been a teacher's spouse, for instance, who lived on a res or on school grounds. If they harmed that person on school grounds, that's really the sticking point for this class action. To give you guys a bit of an understanding of that, we were approached at the ICLC to do a reassessment for an individual who actually, he had snuck onto the school grounds with a bunch of his friends, and they took some methyl hydrate from the woodshed. They then took it off school grounds and drank it, and he did go permanently blind. And so you can imagine that when he was working with an advocate, the focus for him was this life-altering tragedy of him going blind. So his narrative really focused on that. However, when he sent it off, they reassessed him. They said, sorry, this is a level 1 as far as we can tell. The incident you're describing, although tragic, it didn't happen on school property. So they wouldn't recognize that. Now, luckily, I was able to work on a reassessment with him personally. And so I knew that while I can't speak about this blindness issue, what I can do is delve deeper into everything else that happened in his time at that day school. So he actually did suffer some pretty severe abuse. There was a lot of strappings, for instance. The one teacher that he had actually used to have fist fights with a lot of the young boys there, punching them in the face, kicking them all around the school, tripping them up. He was an old military guy, and he used to have them marching around in the basement, and he was just always just very physical with these kids. And so we really focused that narrative on the interactions he was having with that teacher and how he actually developed a deep anxiety and fear associated with the learning environment and the prospect of education. For instance, one thing that actually his wife had shared with me, a memory he shared with her, he said, do you remember when you told me that you went to that school when you were older? And he's blind at this time, and they smacked the chalk brushes on the board, and he smelt the chalk, and it just took him right back to that old day school. And he said he had to leave immediately, and he couldn't actually pursue any education. It was just too much for him. So we really focused on multiple instances of physical abuse resulting in long-term mental impairments. On that reassessment, he was actually awarded a level 4, despite only originally seeking the level 3. So this is one of those instances where the assessor did what they were supposed to do and, judged it off of the narrative and said, no, those are level 4 harms. And they actually did make that adjustment. I mean, this was a kind of an incredible story. I heard from his wife after they got awarded. She called me and said, I'd love to speak with you. And she shared with me that, the week that he'd received his check, they were to go into the bank to declare bankruptcy, right? So it's just one of those things. I mean, it just came through for them at the right time. It was a really positive result. And, he said the money is great, but again, it wasn't just about the money. It was about some recognition of the harms. It was about someone really taking the time and going through a complete narrative with them. I learned his whole life story, right? And I tried to put it in that narrative. So really important. If we could go to the next slide.
Okay, so the next 4 slides, what we've done, I've basically included sample narratives for each of the levels, level 2, level 3, level 4, and level 5. This level 2 narrative, and also these narratives are included in the handouts. And each of these narratives are actual narratives that we've submitted with claim forms. The names have all been changed, and there's I think I blacked out the date of birth of every participant that we've written this about. So they've just meant to give you an idea of what some of our narratives look like. You know, you may be new to the process and you're thinking, well, I don't know how long it should be. I don't know what I should talk about. And just by having these samples to look at, it gives you a real practical idea of the, you know, how long some of them are, et cetera, and that sort of thing. So this first one, so this level 2 narrative, this client, he is from the Okanese First Nation, and he talked about, in his narrative, he talked about how he's been very involved with culture and cultural teaching throughout his life, and even know that he had gone to Indian day school, he was still able to learn a lot of culture from his grandfather, and so much of the narrative kind of focuses on that. And so, you know, you're saying, well, how would you determine? So when actually Jade and I had a conversation about level 2 claims, because our feeling is that if it's not level 1, it's likely going to be level 3, 4, and 5. Like there's very few level 2s. And so I did some digging into all the claims that we've submitted here at the ICLC. We'd only submitted 2 level 2s over the whole course of, I think we've put in already, we have about 50 open files still, and we have about 50 closed files. And so over the course of the last year and a half, only 2 have been level 2s. Now, I went last week, I called this client because I was curious. You know, we submitted this in, I think we submitted it in early 2020. So I thought, you know what, if this is a positive claim, he probably would have already been awarded because we only asked for level 2. So we had this conversation, and when I called him, actually, first, I'm just going to step back. So there's one statement in here in this narrative. It says, so basically the end of the first page, the last paragraph, it says, Rick does not recall any incidents of physical or sexual abuse at day school, but does remember bullying between kids. So, you know, because a lot of these levels of harm have to do with physical and sexual abuse, I think that this was the reason that we chose level 2, because in his own words, he couldn't remember any instances of it. So it's like, this is more than a level 1, but we didn't have anything to talk about because this was what he remembered. And so we just stuck with his story and went with level 2. Now, when I called him last week, he said, you know what, I was just given my letter from the Deloitte, beginning of September 1st, I got it. He was awarded level 4. And so, you know, this is just it's an example of how important a narrative is. This narrative probably only took us maybe 2 to 4 hours of, you know, client and counsel time to put together. I didn't look at the actual numbers on Clio of how much time we invested into this client and how much we invested into interviews, but for some reason, and maybe because he focused on whatever it was in his story, whoever looked at his file, they awarded him level 4 for this claim. So, you know, to me, it is a good example of the importance of a narrative. You know, we had determined this was a level 2 narrative, and I think that they're very hard to come by, because as far as I'm concerned, most of our clients, they have symptoms in adulthood that really, you know, they almost all have PTSD. I mean, almost every one of our clients has PTSD, if you really think about it, because of the trauma that they've experienced as a child. And it's, you know, they've gone into life of substance use. They haven't had a regular job. I mean, there's a huge part of our clients who just, they're not living in regular society, you know, but this gentleman, you know, he went on in life and he did some things, and he was very part of community. So I just put this out as an example because, you know, we chose a level and then they awarded something that was higher than that, you know. So this is a shorter narrative. Most of our narratives run between a page and a half to 10 pages, because Jayden has done, I mean, when it's level 5, Jayden has done some extensive narratives with people, because like he says, he integrates, you know, the complete life story, and you can't write a complete life story in 2 pages. So, you know, but at level 2, we have a shorter narrative, you know, and so that's just, it's because we're not asking for as much. And I don't think that we included any of his, I think we just had a narrative. We didn't have any witness statements for this one. It was just this, and we sent it in. So, I mean, that's, who knows why it was awarded that level 4. I'm glad it was. I congratulated him, and I just said, this is very good news, and I'm glad that he was given that amount. Next slide. So this next sample narrative that we did, this is a level 3 sample narrative. Again, it's about 2 pages. This story is about our client. Her name, we call her Allie West, and she's from Fort Babine, and she went to Indian Day School there. And she, the thing that comes out in this narrative that is over and above what happened to other people is that she has had some permanent disfigurement on her hand and had difficulty writing all of her life. She went on to become a registered nurse, and she had a long career as an RN, but she never went back to community, and had definitely severed ties from community because of these experiences at Indian Day School. So, you know, there was things in her adult life that did hold her back in some ways. You know, she did manage to connect with career and did get an education, but other things were not there for her as much as for other people. But it's this, so when we determined level 3, because it was about her hands and what was wrong with her hands, what we did for this, we had the school photo. This school photo is from Lake Babine. We had a witness statement, which was her sister, who gave an affidavit of some of the events that happened at the school. We didn't have any school records, although we had done an ATIP request, but the client then requested, she said, you know what, I'm tired of waiting and I want to put this in right now. So it was July of 2020, I think. No, yeah, July of 2020, we submitted this application, and she was awarded a level 3 award. And it took about, this one took, I think, 7 months for it to come back. We submitted it in early August of 2020, and she was given the award in March of 2021. So that's another thing that we kind of, I keep an Excel spreadsheet basically of the client, what level, when we submitted the award, and then if they were awarded, or other notes, like if it was sent for reconsideration or something, anything that has to do, we keep a list of sort of all of the files that are done, and so that we can track kind of the time frame of how long does it take. So at this point, we know that that a level 3 to a level 2 to level 5 takes between 7 to 9 months for them to hear back a response. So yeah, just in this narrative, it focused on one particular experience that happened at the school that was very abusive for her, and her sister did an affidavit with that she was a witness to that fact, and so coupled with the picture, and she was awarded this level. Next slide. So Jayden, if you could speak to this one, this is a narrative that you completed. This is actually the reconsideration one that you alluded to just previous to this slide.
Ah, okay, yeah. All right, yeah, so actually this was one that, again, yeah, we didn't start from scratch. It came to us as a reassessment, so we had a quick turnaround on this one. And actually, just because it was such a quick turnaround, we didn't actually have the ability to do much for like a witness narrative or anything with this file. However, we didn't, like, the attendance and stuff was not being contested, so we didn't have to worry about that either. Yeah, it was really, let's find out more about the complete experience. Tell me everything about your life. Another thing why that's beneficial is to really take your time and get the whole life story. Is there's no doubt going to be more class actions in the future. As we know, many of the people who were eligible for this, they might be eligible for these future class actions too. So when we do this narrative, I always tell the survivor, this is your story. You take it with you. And, you know, if there's a class action in the future that requires a narrative, they're going to already have that done. So that's one of the benefits about it. Yeah, and Gloria mentions level 2, and me personally, I haven't submitted a single level 2. There's very little where I see I could end up there and actually not get up to a level 4. So I would anticipate that most of the work you're going to do is going to be level 1 or upwards to level 4, level 5, right? There are some distinctions they make between level 4 and level 5, generally in the way of sexual abuse. Of course, with level 5, they'll want to have repeated incidences of sexual abuse. And whereas level 4, it can just be physical abuse. It doesn't have to be anything sexual. That's pretty much the distinction I see between those 2 top levels. So that's just something to keep in mind. And another interesting thing that happened with this reassessment narrative is that when you're doing this kind of work and you're dealing with clients, these names and places, they stick in your mind. And then it turned out we had another client at the clinic who went to the same school. There was not, the clinician who had it hadn't had the chance to do much work on it. I said, you know what? I know about this school. Let me have this file. So my way of thinking was I can probably find out a little bit more, but also I knew that I'd already have a built-in witness narrative that I could modify for this file as well. That's something to keep in mind. These details are going to stick in your minds. You're going to remember the names of these teachers, these perpetrators. It sticks with you. That doesn't go away. I think for every single narrative I've worked on, I could still tell you the names of all the teachers, the students, the location of where things happened. I can describe what that school looked like. You know, you don't forget those things. If you've had that conversation and you've done your work, you're going to get vivid descriptions. They'll stick with you. So yeah, just some other points to keep in mind about these narratives and, you know, the possibility of witness narratives, which we're going to get a little more into in a little bit. Next slide.
Jayden, someone's asking if there's any issues with a claimant being eligible for compensation for a deceased spouse.
No, because it's an estate issue, right? It'll be, the claim will go to the estate. So now this is an issue for making claims though. Although Gowling is required to provide ongoing legal support for claimants, they will not assist people with resolving those estate issues. So they won't take a claim until this estate issue's been resolved. So that's just something to keep in mind. Now, this is obviously an access to justice issue. I think shame on them. What can I say? I mean, because we certainly get a lot of inquiries about this. That probate process can be, frankly, a real pain. It can be really difficult. So yes, they can get that compensation through the estate. It's not necessarily easy, particularly if someone passed away off reserve. If it's on reserve, it's far more straightforward. So this will be an issue for those who the party was deceased off reserve. There's potential, but there's a few hurdles. Okay, and so level 5 narrative, as I mentioned, really the distinction here, it's going to be multiple instances of sexual abuse. Now, if you look at your harm chart, they're going to say penetration. However, for this level 5 that was awarded, it was overwhelmingly, it was oral, sexual conduct and not a lot in the way of penetration. So it seems that it's just going to be repeated instances of sexual abuse. Yeah, this was another one. Now, in my semester as a student at the ICLC, when the day school just had started off, this file was originally with another clinician. And because I happened to stay on to work as an advocate and then article, I was able to go revisit and look into all of the other day school files, as that was my primary focus. And when I read the initial draft, the clinician had their notes that they thought that this was, probably level 2. But there were just a few things that I was reading in the draft that she'd written. And I go, you know what? It stood out to me that there's a little more going on here, and that I could tell that we just haven't dug deeply enough into this person's story. And so I took conduct of this file and we revisited it. We did a very deep dive. This is a pretty thorough narrative. And if you guys do have the chance to read through all of it, you'll really see how I approach a narrative, the way I like to structure things. I like to tell it as a story. I like to use a lot of block quotations because this is my ability to really put those idiosyncrasies in those block quotations. I want it to sound just like how that person speaks when the assessor's reading it. Again, this is coming down to humanizing. And yeah, it's thorough. It's life history here. And for this one, she was just awarded this, I think, about a month ago. I was anxiously waiting to see how that was going to go, because this was one where there was no possibility of witness narratives, and we could not track down any attendance records. We'd done our ATIP requests. Nothing came up. So we were really pleased with this result. Again, you're going to see it's not just about sexual abuse, it's physical abuse, it's long-term mental impairment, and it's every single kind of mental impairment we could think of and discuss that she'd experienced. We have to put everything possible into these narratives and see what sticks. So just be very comprehensive. That's all I can say.
Yeah, and I just wanted to add something here about the process of crafting a narrative such as this one. And Jayden really focuses on getting to know the client, and he develops that rapport with them. And this has happened with myself as well on certain interviews. When someone comes in, a lot of times the first interview or the second, it sort of sets a timeline. You get the details of kind of their whole life. You talk a little bit about school and they tell you this and that. After that first interview, what I usually do is like we've spoken about, people tell stories not in chronological order. Their stories come in kind of bits and pieces, and they have a flashback from this time, and then they talk about being an adult and how it's impacted them. And so whenever I'm interviewing someone, I go back in after the first interview and I create a story, a timeline chronologically in order. And then at the next interview, what I usually do is I say, could you read this through for accuracy? And if it's, in the right order, and usually the person will say, this is exactly what I said. Yeah, no, this is right. And it is exactly what they said, but it's not in the same order that it was said. It's taken and turned into a narrative. And then from that second one, then we talk about something else. And usually they say, well, could we talk a bit? Do you remember anything about the time when you were a teenager? Or do you remember anything about maybe the time that you'd had a first drink, or what happened there? And I go into kind of almost topical, and then I take those topical pieces and I put them into the narrative. And then often after 2 or 3 interviews, usually it's the later interviews, because then there's developed a level of comfort between you and your client. And then they will share some of these harsher details of maybe there's been sexual abuse. I mean, we don't just jump into stuff like this. It is a process of, starting with just, maybe the the details of like an overview, and then going into more and more details where people feel comfortable. Yes, I could talk to this person, and I know them well now, and I feel good, and I know that my story is protected here, you know. And so when we give them that sense of comfort, then they will allow, you know, to tell you everything. I mean, very rarely does someone come in to me with an interview and say, you know, this is my story, and they start beginning it. Sometimes, yes, it does happen. I've had clients where they said, I've been thinking about this and I know exactly what I want to say. And they do. And they just talk, and I just write. And so, and it's easy. But most of the time it's not. And we have to, I kind of, you know, I ask certain questions to just bring out additional information about, you know, do you remember anything when you were in grade 1? What were some of your memories of your, you know, your classmates? What were some of the things you did at recess? You know, just different things that just get them thinking back to that time. You know, do you remember what happened in the springtime, or what, you know, what are your memories of the winter months? You know, just, it could be very general, but it brings specific things into the story. And so that's how a story turns from 2 pages into, you know, into an 8-page narrative or 9-page, because it takes some time, you know. So when we're looking at a level 2, we may meet with someone for 2-3 hours. You know, it's always going to be at least that long to do a narrative. But the level 5 narrative, it takes hours. And I know when I go into some of Jaden's client work on Clio, and he's logged his hours, it's like he blows me away. It's like, oh my God, you know, he's worked 40 to 50 hours on with some of these clients. It's a long time, but you know what? It's worth it like I said at the beginning, the stories are sacred, and we're trying to really present them in a good way, and so that it is the full story. And that is, you know, for this client, you know, she's very, very happy with the work that Jaden did with her, and you know, they develop a bond because, you know, she's told him many things about her life, you know. So it's just it's the relationship building that happens when you do client work like this. So
yeah, that's all accurate. And another thing, these narratives, they can be exceptionally difficult to write. In fact, this is one of the barriers to people pursuing those higher level claims and settling for a level 1. They go, how would I ever do this, right? For instance, one of my clients that I've worked with is actually a 3rd-year law student who she'll be graduating very soon. She, with all of her education, didn't feel like she could tackle this on her own. So it's just an important thing to keep in mind. This is a real barrier. This is difficult work. It's important work. And yeah, I can't say enough about it. It's also exceptionally rewarding work. Every time you hear that you've got a positive result or that you've made a meaningful impact in your client's life, that's huge. I think we're ready for the next slide.
Okay, we're going to say a little bit here about witness narratives. And these are really, really important. I mean, I think that the witness narrative is the next important piece to doing a narrative, or to doing a doctor's note or anything. It's when you can have someone create a witness narrative or do an affidavit or anything like that to support the story. That's a very strong piece of evidence. And that's what these committees are looking for, is evidence to support the story. So often when we're interviewing our clients, pretty much at the end of any first interview, I often say, can you think of anybody who could be a witness for your story? You know, is there a classmate? Was one of your brothers and sisters? Is there someone who could speak to this and corroborate your story and just be a witness for us? And often there is one person, sometimes 2 people. There's usually no more than 1 or 2. And in fact, we always try and get 1 witness. And occasionally we'll get more than 1 witness, but just having that 1 witness, I think, is a very powerful addition to someone's story. And in fact, I'm just going to say a little bit about 60 Scoop, because, you know, it's 2 years out from the deadline. And just now they're sending all of the people who they're still working on their claims, asking for a witness statement. And it's like, you know what? I wish we had done this with the 60s scoop, way back at the beginning, because right there, even that committee is saying how important a witness narrative is. Jane, you have anything to add on this one?
Yeah, so you guys are probably looking at this image going, okay, what's this all about? Well, this is again, one of the shortcomings of this federal Indian Day School class action settlement is they actually didn't contemplate the ethical issues that arise from seeking these witness narratives. Is how do I corroborate these very personal details of my client without spilling the beans, right? So when I said that the narrative is the most complex or difficult part of the process, really it's the witness narratives that are the most difficult and complex part of this entire process. You have to be very strategic with the questions that you ask when you're trying to get corroboration. And in that FIDSCAS how-to guide, we actually do have a sample of how to do a witness narrative. Yeah, they're very challenging. And not only do you have the ethical issue surrounding, keeping your client's information confidential, but also it's our job not to do any harm. And usually those witnesses, they're the peers, they're the other survivors. And oftentimes these people don't have anyone to assist them on their own claims. So actually this has led into me taking on clients on multiple occasions and doing claims for them. But, that might not be the possibility for everyone. So what will happen is you will be re-victimizing this person. They might not get any real benefit from that. So I very early on, I always try to say, are you interested in getting some assistance with your own claim if you don't have anyone? It's something to think about. And again, ethically speaking, why wasn't this contemplated for the settlement? It's one of those I can't get my head around that, how they thought that this was okay. Because they want to tell you that they're required, but they didn't think about this. So this is very, very tricky. Again, you're going to have to ask very, very strategic questions like, how do I get this piece of corroboration without letting them know that this person was sexually abused, this one thing that's caused them an infinite amount of shame and they've never shared with anyone, right? And so I do give you some examples of how you might approach that. For instance, if you know that your client was sexually abused and you're speaking to a witness narrative, you're not going to mention your client so much. You're going to say, do you recall any sexual abuse at the school? Be general with it. Let that person take you somewhere more specific, right? It could get to the point where you say, do you recall anything happening to our client, right? We just can't start there and say, do you recall such and such sexually abusing our client? It's something that we can't do because we don't know what this person knows. You can have this conversation with your client when you're asking them if anyone would be a fit witness. Say, have you been completely transparent about your experience at day school? Do they know all these things about you? Now, that can be a very difficult conversation to have. Also, I have had the experience of working with siblings on each of their claims, which again, it led into it because I needed one for a witness narrative. And I thought, I can't do that and not help this person who's essentially lived the exact same life, right? So it's tricky. Even with siblings, you don't know if they're going to be completely open about what they've experienced, because what I've come to learn is that most people think that a lot of the sexual abuse was very much something that only happened to them. This was usually something that happened behind closed doors. It wasn't out in the open so much. So you can't take it for granted that another witness might know that this happened to them. So it does create that dilemma. How do we get this information? And it's strategic questions. Be general. Let them take you somewhere specific. That's the best advice I can give about that. It's difficult. It's challenging work.
And then just one other thing about witness narratives that we've done here with some of our applications is that we've done an affidavit And this is one of our siblings. She had her sibling that was in school. So basically she was giving an affidavit that her sibling had experienced this kind of physical abuse in the classroom. So it's not so much a narrative, but an affidavit, but she's swearing to the fact that this happened at a certain time and that she was a witness to it. So we've found a couple of ways to do witness narratives, through narrative and through the affidavit.
Yeah, an affidavit's one way to do it. The other way is usually what I'll do is I'll draft a witness narrative in addition to that narrative I've already drafted, and then I'll create a third document which I intersperse them together. And then the next question is, well, how do we make sure that this witness narrative is accurate? So what you'll then have to do is do a redacted witness narrative of that interspersed document. You take out all your client's information. You seek the review of that person who was your witness to make sure things are accurate. There's a level of difficulty involved in doing this, and not divulging your client's personal information. Also, there's the question, what happens with these narratives once they get sent off to the administrator? Everyone asks that. They are confidential. We always seek for these witness narratives to be destroyed. So we never have the situation where that witness narrative goes back to our own client. They don't need to know what this person is saying. They don't, it can be a little dodgy there. So we just find it best practice to, when we submit the claim, have it destroyed. We give our client everything that we've worked on, their narrative, their claim form. The only thing they won't get is that witness narrative. And that's just because we have to keep that confidential. We're essentially treating that witness as though they're our client as well. I know it's complicated, but there's good guidance in that how-to document, I promise. And next slide. I think we're almost through the witness narratives. I think we've spoken about that. So we can probably go to a question. Jen, you have your hand up.
Hi, thanks. Sorry, I learn a lot by asking questions. So, and this may be in the guide document you're referring to, but are your witness narratives mostly about like these incidents that show like the inciting type of harm, or are they also, or otherwise, about the like impairments and the long-term impacts?
No, that's a good question. And it depends on the nature of that witness. What's the relationship? If it was someone who was just a classmate at the time, it's largely going to center around what they witnessed in the school environment. However, if it's a sibling and they have obviously spent the entire lifetime together, then they can probably speak to the long-term impairment as well. For instance, a lot of our clients, they fell into alcoholism and substance abuse, and that was a lifetime issue. And sometimes the siblings have seen that over the course of their lives. So it's easy to corroborate that. So it just really depends on the relationship of the witness to the client.
Do you find that the assessors, though, are like primarily looking for like firsthand witness of the like original harms, or is it like, as you said, whatever you can get? Like if someone's like around the person while they're a child, is that quality of evidence important, or it's just like what you have?
I mean, that's a first-hand account still, if they have that experience and they've seen it and witnessed it. As long as if it's firsthand, that's better. Where you might come into some issues is a hearsay kind of situation. I mean, they're still going to assess it like we would in the law. Generally, there's a burden of proof to be considered, and of course, when we're seeking higher level claims, that burden goes up a little bit more. So, the quality of the source is important.
I think there's another hand there as well. Short question?
Yes. The one thing that I found on some of the written narratives is that we're adding how that abuse has affected them later on in life, i.e. the addiction issues in regards to drugs and alcohol. And what I've been doing is submitting medical reports from their doctor that accompany their written narratives, so that, as you say, the more ammunition that you can pile onto the claim adds to that strength. And I've also always included statements about intergenerational trauma that has affected family life, their kids and other family members. But the one thing, and I don't know how it is down south or the rest of BC, but here in the north, there has always been a tradition amongst our First Nations up here, whether we're Haida like myself, Tsimshian, Niska, Gitxsan, is that our clients have always felt an obligation to compensate you for the work that's been done. And it's really taboo to refuse gifts in public. So when we have clients here, we make sure that it's explained very, in a manner. I understand the tradition, but we get paid. There is no obligation on anybody to compensate us through gifts or what have you, because they feel that that's obligation. And to me, accepting any type of monetary gift from a client would be like dirty money in my view. And it's a very fine line you got to walk, because you're also dealing with people's status within the community and their genealogy from which clan and chiefs or grandsons of chiefs. So you also got to walk that ground in a very delicate manner as well, right?
Mm. Great. Thank you. Okay, back to you, Jaden.
Yeah, I think we're done through the witness narratives now, Gloria.
Yeah, we're going to move on. So this one, I wanted to just mention this to keep in mind your client. We've learned through the grapevine that it's important to work into the narrative that your client may have symptoms of PTSD. This can be certified by a doctor's letter. Most of our clients can go visit a doctor and have some sort of letter to the fact stating that they have symptoms, and it could be anything such as this. So there are many symptoms of PTSD, with a few being having flashbacks, having nightmares, mentally re-experiencing the traumatic event, feeling numb, avoiding things that remind them of the traumatic event, feeling disassociated, having increased mental and emotional arousals, having difficulty sleeping or concentrating, having issues with anxiety, feeling jumpy, irritated, anger issues. So there's just a huge list of things. And one of the clinicians that's been working in the clinic over the last couple of months has said that his uncle, who's working kind of within the system with many Indian Day School clients, has said that when there's a mention of PTSD, it can possibly bump up the story a little bit more. So I just wanted to kind of bring attention to this as something to keep in mind, just be aware of, and that if you think at all that your client may have any of these kind of symptoms, to include a paragraph at the end of the narrative that is corroborated by a doctor's note, and most doctors would be willing to do that for their clients. Next slide.
Yeah, the sworn declaration, we've already kind of spoken about that. It was something that when we had just started working on these claims, I was pretty concerned about. I didn't know if it was given substantial heft in the way that the actual corroboration they were seeking would. So far, we're relying on a sworn declaration for every file. It seems to be given substantial credence. So I'd say don't worry too much about that. But also, I would say as a default, you're going to do a sworn declaration on every single file. No matter how much information you have, still do the sworn declaration.
Yeah, it's kind of a fallback. And just because, I mean, one thing that we've done for every client is we've asked for an ATIP request, and we only receive maybe 10 to 15% of an actual result of school records or something like that. So we always include the sworn declaration just for that fact that we almost never have a school record. And, you know, because this is 50 years ago, a lot of these records are just not, they're not in existence anymore, you know, and so we rely on this for everyone.
Okay, we have to say too much about this. In your FIDSCAS how-to, we take you through the entire process step by step in that document and how to make an ATIP request. Also, we have a discussion about the different types of ATIP requests you might be making when you're working on a claim, and there'll be specific instructions for that as well. For instance, you might be making the same request to multiple entities. Searching for school records, it might not be with Indigenous Services Canada or CIRNAC. It might actually be with Library and Archives. So you're going to probably send out duplicate requests to these multiple agencies. And that's something to keep in mind. Again, this is laid out in that document with examples on how you would draft one of these requests as well, depending on what you were seeking.
Okay, this part 7, are you applying as a representative for a claimant? This page is if one of your clients is applying for a deceased spouse or brother or sibling or family member. Now, at the ICLC, I mean, these are definitely more complicated because what the first step is that if there is no will in place, and pretty much 100% of the time there is no will in place, we have to pursue letters of administration, which is a complete process, much more complicated on top of doing the Indian Day School application. So what we've been doing is that we're opening files, working on letters of administration, and then we decided that if, you know, say in January or February of 2022, if we haven't received letters of administration, what we'll do is we'll apply for our clients just to get it in before the deadline, but then they know that we're still working to get the letters of administration put through, because it is really more of a two-step process. And sometimes these letters take some time.
Gloria, there's a question that for level 1, do you only need the claimant's signature and witness signature and not the sworn declaration?
Yes, for level 1, you do not need the sworn declaration. Once you click off level 1, then I think it's page 1 to 5 is really all that's required for that application form.
Yeah, unless they weren't able to provide the identity that's required for it or something like that. If they didn't have any ID or a status number, then you might do the sworn declaration as well.
That's true. Yeah, that's right. Okay, so this is the last page of the claim form. We always ask our clients what they want to have done with their documents. The first choice is securely destroyed. The second choice is returned to you. And the third choice is delivered to the legacy fund. And most of the time, our clients will want it returned to them. That's been one of the big responses. Some people say give it to the legacy fund. The legacy fund is a fund that is meant to provide community support and educational opportunities for survivors and family members of survivors. And it's not, I don't think it's been created yet. It's something that's in the future. But what I think they hope to do is use some of the narratives and use some people's stories in order to educate, in order to tell people about, you know, this is what happened to people. This is, you know, somebody's narrative can really, you know, really touch someone's heart and saying, you know, I didn't know that this happened, you know, and it is a way to educate. And I think that that's what the intention of the legacy fund is, although we don't really know what it is until they create it and it's out there. But in other class actions, they've always put together a legacy fund where It's meant for families and communities to create events for community healing. And so these are the choices. So we always have our clients choose one of these things. Okay, so this is the submission process, the last page. It's always good to just have a final read through on everything you have, make sure that you've got all the listed documents, all the appropriate pages filled out. I always have another set of eyes look at things. Sometimes, you know, we have the clinicians do the application. I go through it just to make sure everything is complete. We always make sure that the client's contact information is complete and up to date, because it is the claimant that will be communicated with through Deloitte and through anything that's happening with their application form. Because basically once we've submitted on behalf of the clients, we don't hear anything else. We don't know if it's been approved. It all goes to the claimant. Next slide. So we've included a little bit of information about the time estimates. This is what we've learned based on everything that we've sent in. Level 1 can take about 2 to 3 months in order to be decided. You receive a payment letter to confirm a claim has been approved, and the client receives a check for the amount. Any other level 2 to 5, it can take 7 to 9 months. This is what we found to be about the average. And sometimes the claims are also sent to the Government of Canada for a second look, so which means it's going to be longer than the 7 to 9 months. So this comes from the website of Deloitte, and this is the overall current as of September 1st, 2021. Claims received to date, 123,000. Claims determined as needing more information, 11,128. Claims currently in process, 22,720, and claims paid, 89,283. So 73% have been processed to date. Additional.
Gloria, sorry, Gloria. There's a question about reconsiderations of reassessment. Do you have any information on that process?
We've sent in 2 reconsiderations in the last year, and both of them took about 2 to 3 months to approve. They're actually were fairly quick once we'd sent in the new information. Right?
Is there a form for that, or you just?
I actually, Jaden, you speak to that because you sent in the.
Yeah, absolutely. So in the event that they're going to be reconsidered, the claimant is going to receive notice of that with instructions, and they're given a time frame at which time they have to get this claim in if they're going to contest it. The other option, of course, is just to accept the level that they've been assessed at. So this does push up the timeline on the claim. So that's why I mentioned earlier on the reassessments is that you might not have time to do witness narratives or seek certain records, right? Because it is a quick turnaround on those. So also in this that FITSCAS how-to document, I do have a whole discussion about reassessment files. And it'll give you the timelines of those and instructions on that as well, how to approach that. So yeah, those can be complicated, but they're going to have a quick turnaround. So that's something to keep in mind.
Okay, so this slide is about additional notices that you may receive. The first here, that there's some missing information. And this is like that final puzzle piece that you're just looking for. It's such a frustration, and you have to look for that. So we help our clients look for that missing information, and then we send it in as soon as possible. Another thing is that the letter is advising that your level 2 to 5 claim is being sent to the Government of Canada. I mean, at this point, we know of a few of our clients that this has been the next step, and so we're just waiting to hear from them about that. Next slide. You claimed level 1, but the administrator feels that you qualify for a higher level, or you have been reclassified at a higher level. This does happen, and one of the samples that I actually talked about, that level 2, that narrative that we created, it was awarded a level 4. And so sometimes we put in for a certain level and it's bumped up. And then lastly, your claim is being sent to the exceptions committee to determine the eligibility based on attendance at a non-scheduled K school and or year attended. So we encourage everyone to apply, even if it isn't on the Schedule K, because there's other ways to get through this application process. And we just, you know, I think it depends too on doing a narrative, as if they can read that, they may reassess it and say, you know what, this is going to be an approved claim. Next slide. Okay, so I just put this up basically at the end because there are other resources out there, and I wanted to make a note. I haven't put it up onto our site yet, but I've been picking up resources about working with people with trauma. Other resources are, you know, going to the library, finding resource books on trauma, PTSD, what does that mean? You know, compassion fatigue, working with clients where you hear trauma all the time, you have to look after yourself, you know. So just as a note, when working with clients, we don't want to carry it home with us. And so what I'll do is I'll complete that resource page of, you know, different books and things, and I'm going to attach it to our site that's on the Legal Advocates Conference page. Just so you can take a look at some of them. A lot of helpful hints there. And sometimes it's good to educate ourselves before we're working with people with trauma. You know, those resources, there's always things online, but I think it's good to do additional reading and, you know, just get educated, because if we know that we're going to be listening to trauma stories, we can protect ourselves and do things in a more healthy way for ourselves, which is very important, so that we don't want to get jaded in the whole thing just from hearing stories that are very difficult. Jaden, do you have anything to add?
No, I don't think so.
Any other questions, or there's been questions along the way? I think we've caught all of them. Thank you very much. It's a very interesting presentation and really useful. Like, there's just so much information that people will be able to use. As you'll see, everybody, Alessia's put in the chat that all the materials are on SHED. Gloria, we just in the background changed your PowerPoint so that it doesn't show the notes. It's up as a PDF now. So yeah, people, if you want the resources, they'll be there. We've got the recording of this session. It has to be edited and uploaded. So that'll be later in the year. Don't look for it the day after the conference ends. It's going to take us a bit of time, but it will be there. And I think Alessia noted in the notes where it's going to be. So I think that's all. Thank you. If you all want to come on your screen to wave goodbye, we could do that. Always like doing that. See, there you are.